Hello, my name's Dr. Brett Davies. This question was being asked by a mum and dad that are in a loving husband and wife relationship or a de facto relationship, it makes no difference, and they have children only of that relationship. In those circumstances, it's usual, you don't have to do anything, but in those circumstances, it's usual for mum to leave everything to dad and for dad to leave everything to mum in the first instance. And then upon the death of both of them, everything goes equally to the children. That's what I've done in my will with my wife. That's what most people do in happily married first relationships of children only of that relationship. Got blended families? Well, that's another issue. But just got mum and dad with the kids, then you may well wish to appoint your spouse as the executor. And then if she's dead or he's dead, then have the backup executors being the children. If the children are still young, then still appoint all the children, but also pick up a couple of uncles or aunties from both sides of the family. If when the children die, when the parents die, the children will probably be around the 60s years of age, then those uncles and aunties are no longer required and the children can go on and get the administration of the estate done. I think there's advantage in having the children, even though you might have an age of majority of 25, I think there's still an advantage of having an 18-year-old as one of the executors. They have to act unanimously, so that 18-year-old child, because the age of majority is 25, can't get their hands on the loot to their estate, their proportion of what you're giving them until they turn 25. But during that time, that 7 years, they've got to work with the financial advisor, the accountant, the lawyer, the other brothers and sisters or the uncles, right up to the time they're 25, and that's difficult. A lot of work there. What do I do with the investment? Should we pick up some BHP shares? Should we put more money into a managed investment scheme? They're all issues which make, when the child turns 25, the money's not such a windfall. They can see the work that's been taken and needs to be taken on an ongoing basis in order to protect money. So I would suggest that you appoint the children, if they're underage, to still be the executors, but have a couple of backups, like the uncles. If you're in doubt, just telephone us. We're a law firm, and we can help you give legal advice on how to even answer the questions. That's the advantage you have in using a law firm.